Welcome to the JPG podcast, value added content to enhance your property experience in Jamaica. I'm your host, Mike Johnson. Around 70% of land in Jamaica is in private ownership, but only approximately 50% is registered. To boost the uptake of title registration, new legislation now offers you an alternative and a more streamlined process to follow. My guest today is Attorney at Law Georgette Stewart-Harrisingh from the Land Administration Management Division at the National Land Agency. I began by asking her how the two pieces of legislation differ when it comes to the practice of land registration.
To register land, you are usually required to make an application under the Registration of Titles Act. And some of these requirements are quite stringent. So, for example, you need to show that you have been on the land for over 30 years. You have to establish what we call good root of title. And in order to establish that, you need documentary proof. The problem with that is that we have a culture in Jamaica where we don't pass land by document. We do a lot of word of mouth. So your grandparents point out a piece of land and say, that one is yours and that one belongs to you. But our law requires that you have documentation. So the difficulty that the average Jamaican has is that in order to provide a documentation, there are a number of costs associated with getting this done. So for example, say your grandmother did a will, left the property for you, that will have to be probated. You have to pay death duties. The property has to be transferred to the executor or the administrator, who then needs to transfer it to the beneficiaries. And so you have to show the registrar, the referee, all that information, documentary information, to show him how you came by the land. And in addition to that, you also need to establish how your grandmother came by the land, which would have, need to show at least 30 years of that happening. So it is and has been really difficult for persons to obtain titles over the years. In addition to that, you're required to have a plan, a subdivision plan or a diagram. And the cost of a diagram is pretty expensive for the average Jamaican. And then if you're taking off a piece of land to a bigger piece of land, then you need to get subdivision. The problem with subdivision is that the surveyor literally has to survey the entire property. So say you have a 10-acre piece of land and you're trying to get off a quarter acre, you can just imagine the cost of doing that. And so that really has been a deterrent to many of our clients. It has been a deterrent to the attorneys who are trying to assist their clients in obtaining this title. And so in 2005, an act was passed called the Registration of Titles, Cadastral Mapping, and Tenure Clarification Special Provisions Act. And as the name suggests, it's an act that is supposed to assist persons with registration of titles. And there's some element of cadastral mapping. So when LAMP, which we are now Land Administration Management Division, which is a joining of LAMP, which was previously Land Administration Management Program at the National Land Agency, when LAMP had started, they were given funds to go into particular areas. And so they were able to do cadastral maps. So instead of individual surveys for each lot, they did big maps for the particular area that they were in. Now, persons who have land that falls within those areas don't need to get a survey because the cadastral map would have a lot number and we could use that to assist them. So that would save them that survey cost. And then there is tenure clarification. So tenure clarification has to do with those persons who already have title. So there's a registered title in their name, but they want to do things. They want to add somebody to the title, for example. They may own the title jointly with someone and one person has died, so they need to take off somebody's name for notation of death. Or they may need our assistance to do the preliminary work before registration, which is an application to the Supreme Court for a grant of administration or a grant of probate in the estate. So this particular act came in to do away with some of the stringent requirements. So for example, if you can show that you have been on land for over 12 years, you may not have the documentary proof, but you have possessory proof. You're in possession and you have declarants who are willing to show that you have been in possession those matters under the Special Provisions Act can be referred to an adjudication committee. And that committee consists of an attorney, a surveyor, a representative from the district, a representative of the minister, and the matter is heard in a community setting with community people involved. So, an old lady will say, yes, I know the property. It belongs to Mr. John, and Georgette is John's granddaughter. And Georgette has been living on the land for the last 15 years, and everybody sees Georgette as the owner. And based on oral evidence given, the adjudicator can make a decision declaring that person to be the owner of the land. Once that person is declared to be the owner of the land, then without the document or proof that is strictly required by the Registration of Titles Act, the application can be sent to the Titles Act, this time bypassing the referee and going straight to the registrar for a registration to be done within 6 weeks, subject to that certificate.
Right, I understand that, and I can see some benefit of that for those who cannot have any kind of proof. But if I was the original landowner, I'm thinking, I need to be in touch on a regular basis with what's going on with my land, just in case someone has come onto the land. And, if I've done nothing for 12 years plus, someone could legitimately claim that, as their own.
Right. So we have what is called a Limitation of Actions Act.
Oh, right. Okay.
And that limitation limits how long, the amount of time someone can have to bring an action, for example. And so there is, and that's something I want to say to persons, when you own land, you have a responsibility to protect your land and to protect the ownership of your land. So it's not a matter of just owning land and having your name on a piece of paper. You have a duty to possess it. You have a duty to secure it. You have a duty to keep it cotton so it doesn't disturb your neighbors. So if you've gone away for 20 years and you've never been back to the land and it's now bushed up and it's now a forest and rat is running out of it, it's really becoming a nuisance to your neighbors. So if somebody comes in and takes control of that land, cleans it up, plants on it, builds a house on it, and you're coming to Jamaica every year, but you've never gone to the person and said, listen, this is my land, or taken some kind of legal action to say you're trespassing, then what you're in essence saying is that I really don't care. It's okay, go ahead and have my land.
Yeah.
And so the law allows for you to be dispossessed. In essence, So it's not as easy, but it really is an issue of possession.
Yes.
When somebody's in possession of your property, there's no way that you can't do, because somebody's going to pick up the phone and say, somebody over there planting on your land.
I understand also from a surveyor that if let's say I occupy a piece of land, I clean it up, and so on, I build a house, I build a new roadway on it. If those actions have not been challenged in the past 7 years, then what I've done now stands as this is what is in reality on the property. So when it is surveyed, those changes that I've made are reflected on the diagram.
Right. And that, of course, has to do with the limitations of Action Act, because you have a particular time within which to object, to bring somebody to court to say, listen, you are encroaching on my land, you have moved my boundaries, and so you can silently acquiesce to someone taking possession of your land, because just by being silent.
You're with me, Mike Johnson, on the JPG podcast, and I'm speaking to Attorney at Law Georgette Stewart-Harrisingh from the Land Administration Management Division at the National Land Agency. Our conversation now turns to the definition of registered and unregistered titles and how they differ. Let's say something has been left to me, a piece of land has been left to me. How do I know what type of title I have?
Okay, so all lands, as far as is possible, are noted under our valuation system. We have a valuation system. So all parcels of land are recorded, and each parcel of land is given a valuation number. And with each parcel of land, also with the valuation number, by valuation number, you can check whether or not this land is registered land or unregistered land. So for unregistered land, what you have is someone who has been on land, has had possession of the land over the years. They probably have what we call a common law title. So conveyance, or I don't know what the old time person used to call it, like a indenture. They call it an indenture, you know, that would have been signed up by the parties and stamped at the stamp office. But it's not a title that, it's not a land that has a registered title. The registered title now is title that is given a volume and folio and is registered in the registry under the Registration of Titles Act. And so for every land that has a registered title, the referee, the registrar also issues a duplicate. So there's an original title that is kept at the title office registry, and the owners are given a duplicate with which they can do business. Every transaction that happens on your duplicate is also reflected on the original title at title's office. And it is for that reason, if your duplicate title is lost, the information that is recorded at the registry can be used to obtain a new title for you.
Right.
In the event that you lose it. All right. So that's the difference really between the registered and the unregistered. One is unofficial, one is a common law title, and one is actually kept at a registry.
Yeah. And how easy is it for me to move from one to the other, from unregistered to registered?
Right. So that was what I was saying before, that as you had indicated, nearly 50% of the lands in Jamaica are unregistered land. And the reason for that is mainly the cost of moving from registered to unregistered. So again, as I indicated, you have to show root of title. And root of title requires you showing 30 years ago who owned the land. And if the land was passed in between that 30 years, to know how it was passed. Was it passed by will? If it was passed by will, it needs to be probated. Was it passed by sale? If it was passed by sale, you need a sale agreement. You need to show that duties were paid at the stamp office and that a transfer was done. So those documentations would need to be provided. On average, to do a probate, you're looking at anywhere between 300,000 and $1 million, depending on the value of the property. Estate attorneys charge anywhere between 5% and 9% of the value of the property to do a probate. So you have that cost. Then there's also the cost of registering the land. So the attorneys, I think probably the cheapest attorney you'd find right now to do a registration would charge you at minimum $300,000 to do the application as legal fees. And that, I believe, may be the minimum cost. So don't quote me on that.
Sure.
Right. But in addition to that, no, the client also has the cost of survey, because they must get a survey diagram. And the average survey diagram is ranging anywhere from a quarter acre between $85,000 and $100,000 right now for a quarter acre of land. And if you have to move it, cut it off from a bigger piece of land, which requires subdivision, that could probably run you into millions, because then you need the surveyor to survey all of it, cut it off, send it to the parish council for the parish council to do the approval. The Special Provisions Act, however, has been put in place to reduce some of these costs.
Yes, I can see some benefits, some cost benefits. But what about the time it takes to conclude these matters? Is there an improvement there as well?
Okay, so, right. So before we get to the time, Mr. Johnson, let me just get back to the subdivision. But I need to give you the alternative. So,
okay,
as I said, the alternative to go into the parish council is to do an application to our department. Once you can show that you have been on the land, so there's been an informal subdivision for over 7 years, then you can, and it's proven to us, we can actually ask for a waiver. And that waiver costs between $10,000 and $20,000, as opposed to if you were to go with the subdivision, which will probably cost you $700,000 to $1 million. But for that to happen, you still have to show that you'd have surveyed the land 7 years ago. You have been on it. You've been treating it as your own. So you have your own electricity, you have your own water, those kind of basic stuff that would inform us that you are really informally cut off from the land. All right. So that's one of the benefits under the Special Provisions Act. So in terms of the timeline for delivery of these things, so you say, is it cheaper, but is it that you're waiting longer? Right.
Okay.
And I start off by saying that persons, if I were to go to the doctor, and if I go to a private doctor and the private doctor charges me $10,000, but I get to within 30 minutes of me going there because I have an appointment, I'd rather go to that doctor than go and sit at a public hospital and wait for the entire day. Right? And I think a lot of persons have taken that position. The change that we have made with Land Administration Division is really intended to not have our clients have that experience. We want them to pay less, but still have first class customer service at the end of the day. And so, under the old system, the truth was it didn't work. And it didn't work because at the time, Land Administration Management Program was doing work on behalf of the entire island. You can imagine all the attorneys would send matters come to our department here to prepare documents for an entire island. Thousands of files. You must have delays because it's 20 persons to prepare, but thousands of persons was impossible, right? So what we have done to allow for more efficiency is to give persons the option to have other persons do the preparatory work before it gets to us. So as indicated, you have two options. You can go to Geoland and have the attorney prepare the documents for you. So all they're doing is sending it to us for certification. And we do our certifications. We have a 20-day turnaround for certifications. Once the matter is, a file is opened, we return those documents within 20 days to the attorney. The other option is to go to your attorney. So you may say, I want the reduction in registration fee. And I'll give you an example. If I give you an example of the $12 million, if you were to go the regular route, that if your property valued $12 million, you're looking at between legal fees and registration fees at about $700,000, right? If you have your attorney still charge you their legal fee, but get the reduction in the registration fees and so on, then you'd be basically seeing a saving of about $200,000. So there are some persons who say, I'd prefer to go to my personal attorney, and I know my attorney will prepare the documents quickly, but I know I can get the fee waivers.
Yes.
So they'll go through their regular attorney.